Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammy. I am Executive Director and Vice President of Legal Studies here at Washington Legal Foundation. For those of you not familiar with the foundation, we are in our 44th year of public interest law, firm, and policy practice. We are a nonprofit organization that fights for fair and clear rules for the conduct of business in the United States, as well as economic liberties. If you have any interest in learning more about us, check out our website, wlf.org, after the program's over. Likely everyone on this webcast has seen or heard of the February incident during a Texas State Court's virtual hearing where an attorney appeared on screen as a cat and had to explain to the judge that he was not in fact a cat. Even my 16-year-old heard about it. It went so viral that a Florida craft brewery has released an IPA called I'm Not a Cat, Judge. And here, I'll show you to you right here. There it is. There certainly is a much more serious side to virtual judicial proceedings and the impact COVID-19 has had on the administration of justice. An enormous backlog of cases has piled up in states across America, and the pressure to proceed with them has led courts to go forward virtually and engage in some experimentation along the way. Now, why is this troubling? Because parties' fair trial rights have often been an afterthought in that process. And because there's a real risk that some procedures adopted in the fog of the pandemic may become permanent. What can litigants do to protect and preserve their fair trial rights, and what should courts be doing to better respect these constitutional freedoms now and going forward? Our panelists today authored a March 5th Washington Legal Foundation legal backgrounder addressing some of these questions, and we're pleased to have them with us today to continue and expand upon that discussion. Now, before I introduce our speakers, just wanted to let you know that we are recording this session today. It'll be available as an on-demand file later on in the day. Also, if you have any questions during the program, you can click on the Q&A tab in the chat box to the right of the screen. And also we have as downloads the paper that they did for us, as well as a collection of their slides. So I've gone and introduced our panelists. Wendy Lumish is a managing partner of Bowman and Brooke's Miami, Florida office, and also leads the firm's appellate and advanced motions practice group. Her primary focus is on legal issues and appeals in defending product liability, personal injury, and medical malpractice cases. Joining us from the firm's Phoenix office is Amanda Heitz, who's also a partner with Bowman and Brooke. She focuses her practice on defense of product liability and class actions, including at trial, as well as advanced motion and appellate litigation. Finally, we have Daniel Rock, who's an appellate associate in Bowman and Brooke's Miami, Florida office. Prior to joining the firm, he served as a senior law clerk for Chief Judge Leslie Rothenberg at the 3rd District Court of Appeal for the state of Florida. Wendy, I'll hand it over to you.
Thank you, and thank you for that introduction. Thank you all for joining us today. We have a lot to cover, so I am just going to jump right in. As Glenn mentioned, there's a lot of pressure to try cases. There's a huge backlog of cases around the country. I just pulled one study here. Florida has 1.1 million cases, more than normal, and they were already a very busy court. So you can see the backdrop of the issues we're going to talk about today. Next slide. The pressure is just huge. Probably one of the most overused words we've heard when dealing with the pandemic are flexibility and expediency. We just have to do all of these things. Our concern and the issue we want to talk about today is at what cost we're willing to be flexible and or expedient. And there's some real concerns that we think need to be addressed. So the focus of our presentation is on protecting the critical rights while being pressured to move forward with trials. And importantly, thinking about what those agreements will mean for the future once COVID's in the rearview mirror. Next slide, please. A major concern is that the ideas that have been used recently and the quote unquote solutions that courts are coming up with haven't been tested. It's just a race. We've got to get a trial, so let's go out and do whatever we can. And without careful thought about what's going on, our rights can be trampled upon. I picked up this one quote from a recent case where the court said, "This is an experiment." That's a little bit scary. I think it probably should scare all of you as it does me. We're just going to experiment and hope it comes out right. One court, for example, in California, is experimenting with the idea of taking a multi-party asbestos case and trying them one by one. Not quite sure how they're going to figure out the comparative fault of all the defendants with separate trials. But experiments like that are very scary in terms of what will happen. And we don't have the appellate guidance that we would like to have on these issues because, of course, this is all novel. So it's very important that we make arguments, whether we have citations to law or not. We need to think about what those arguments can be and make them and preserve. Next slide. So what rights are at stake? Today, we want to talk about a couple of different categories. We're going to talk about some juror-related issues. Amanda's going to talk about that in a minute. We're going to talk about courtroom procedures for in-person and hybrid trials. Daniel will talk about that. And then we're going to talk about the virtual trials and how rights are being affected in that regard. So with that, let me turn it over to Amanda, who's going to talk about jury issues.
Good morning and good afternoon to those of you on the East Coast. As Wendy said, my name is Amanda Heights and I'm a partner in Bowman and Brooke's Phoenix office. And I'd like to discuss a little bit about preserving your right to a full and fair jury during the time of COVID and after. So as Wendy noted, there have been a lot of calls for flexibility and in the time of COVID and its aftermath. And with all these calls for flexibility, corporate parties really need to know where to go with the flow and when it's worth challenging what the court wants to do or what an opposing party wants to do. On the one hand, you have finite litigation resources, so most of the time you can't fight every battle. Nor do you really want to fight every battle because you don't want to be seen as an obstructionist in the courtroom. If you make frivolous objections, you're going to annoy your judge. And if you make a lot of objections without merit, you may be burying your good arguments. Without a doubt, preserving your right to a full and fair jury is worth the time and effort it takes to raise a good objection. So the first subtopic I'd like to discuss is fighting a shrinking jury. So what do we mean by a shrinking jury? The jury pools itself are getting smaller. There are people missing, and we know this just from hearing about the pandemic. It's a rule of thumb that retirees are generally very reliable jurors. Suddenly they're in the high risk category. With vaccines, things are getting mitigated a little bit, but the CDC is still recommending guidance among people who are vaccinated going out among people who are not vaccinated. So we have one of our highest turnout groups suddenly becoming more cautious, less able to be there. People like frontline workers who are busy working in our hospitals and our schools, and we need them to be there. Then a topic that some people don't always consider is parents. For those of you out there with school age and younger children, you know that even if their schools and their daycare programs are open, all it takes is a phone call that says somebody in their class has COVID and you are in a childcare crisis at home. And you're either trying to work from home with a small child or trying to arrange alternate childcare or overseeing online school. That's not a great recipe for an attentive juror. Then there are going to be other groups that we may not even recognize yet. We don't have data, as Wendy said. We don't know what exactly is going to happen to jury pools in the pandemic, but there may be other groups of people that we don't necessarily have. So as a result, our courts are dealing with fewer juries. There have been calls for absentee leniency. Organizations like the National Center for State Courts have been recommending that courts adopt generous policies. Don't penalize people who are absent. Be very kind about excuses. We have fewer jurors in general, absentee leniency, and then there's the trial backlog Wendy discussed. We have social distancing, and then on top of that, we have case priorities. In most states, there are defined groups of cases that get trial priorities, with criminal trials up there at the top, trials involving children and family issues, a lot of times probate, and then way down at the bottom, civil cases and tax cases. Depending on where you are, tax may be more important than civil, or civil may be more important than tax. So as a result, we have lots of cases and a smaller pie in which to distribute them. And the courts are in a little bit of a crisis. They're spread thin and need to figure out creative solutions. Often their solutions have seemed to be shrinking civil jury sizes. And there are a few ways to do this. In some states and in some jurisdictions, there are requirements of how many jurors there are, and that's a hard rule to change. In some states, it's rule-based, and an emergency order is all it takes. There's informal pressure to stipulate to smaller juries, and then there are some waivable rights. Here's some examples. So under Federal Rule 48, you required at least 6 jurors, but no more than 12. A federal court could say, hey, you're getting 8. The states vary, and there are some hidden surprises. So in Tennessee, you must ask for 12 jurors at least 30 days before you go to trial, or you're getting 6. If you don't know rules like that, you could find yourself trapped. So why is this such a big deal? It's always been common knowledge among defense attorneys that big juries tend to be better for us. And the social science research is really starting to back that up. There have been studies going back to the early 80s where the American Bar Foundation Research Journal in 1982 said that it's really hard to get a representative jury with 12, but 6 is even less likely. The National Center for State Courts commissioned a literature and review in 2004, pointing out some of the problems with smaller civil juries. One of the things that's been found in a few studies is smaller juries do equate to more outlier verdicts. Bigger juries will tend to have verdicts within the bell curve. Smaller juries will have people very, very low verdicts, very, very high verdicts. There have been some studies showing that smaller juries have reduced evidentiary recall. Social science and psychological experiments going back to the 1960s, finding that in small groups, people are willing to go along with facts that they know themselves to be not true at all, just in the pressure of getting along. That tends to be mitigated when you get into a bigger group dynamic. So this is an important issue. You want as many jurors as you are entitled to get a fair result. And people have been concerned about this for years, but COVID-19 might be the perfect storm that's making all the attorneys stand up and take notice. So what do you do about it? First, you have to make a plan, of course. If you have a choice, don't stipulate. That's the easy one. But if you don't have a choice, you need to be smart about your objections. First, object in principle to your smaller jury. Second, raise specific objections about the venari. What is it about the particular group of jurors that you were allowed to pick from that made having a smaller jury harmful to your client? And third, as always a reminder from appellate lawyers, object before the jury is sworn. You don't want to waive your objections by not objecting on time. Now, a related topic, what about fair representation? This seems like a really intuitive argument. As I discussed, there are discrete groups of jurors that we expect may not be present on our jury pools at the same rate that they once were because of COVID and its aftermath and concerns about contracting the illness. So is this a good argument to make, that you have a constitutional right to a fair cross-section, and if predictable people are absent, suddenly we aren't going to have that? At first blush, it seems attractive, but when you dig into it a little bit, this is a very hard challenge to make. 28 USC 1861 declares policy that in federal courts, you're entitled to a trial by jury and have the right to juries selected at random from a fair cross-section of the community. It's the selection, not the venari itself, or not the panel itself, I apologize. We have a Supreme Court case that lays out what you need to show to make a proper fair representation challenge, and it's onerous. You have to prove that the group that you're not getting is a distinctive group, and that representation of this group in the venari is not fair and reasonable in relation to the number of persons in the community. That means you're going to have to find out information about how your court pulls jurors, the statistics in the community, and you need to do your homework to make this challenge. And third, and possibly the most difficult one, is you have to show that it's systematic exclusion. People just not being available because they're concerned or because they do have a legitimate public health reason not to be there. Is that really systematic exclusion? We're not really sure. This is a new topic. We don't have the appellate guidance we need. So if you'd like to raise an argument like this, you really do need to proceed with caution. Remember that it's the high burden. You have the right to draw from a fair cross-section, not to necessarily have a fair cross-section on your jury. Then you have to show the distinctive group, that it's not a reasonable cross-section, and that the reasons that people are not there. And there are also some traps to be unwary. If you make a facial objection before you even get to see who is in the jury pool, you could find yourself trapped. We don't know a lot about who will and won't report, especially as vaccines are being rolled out in every jurisdiction, and different communities may react differently to how they can behave once they're vaccinated. There's a chance that when you get your jury pool, it won't mirror the trends that we're predicting. You may show up for jury selection and find that this is a pretty fair looking group, and you've made what looks like a premature and sort of baseless argument. Now, even worse, what if you get that jury pool and you start talking to them or looking at their questionnaires and you say, wow, these look like a really fair, good jury for this trial. But your opponent looks at them and says, this seems like a bad juror for my case. If you've objected before you've seen the pool, you've pre-endorsed your opponent's objection on representation grounds. And you don't want to pre-endorse an objection that you're later going to oppose. So it's better to wait. Wait until you see it. And in the meantime, learn the rules. Know why this group may or may not be unrepresentative. See who's going to appear. Another issue that might come up is what happens if you get what looks like a fair cross-section in the jury pool, but the judge, exercising the discretion to be lenient with excuses, says, okay, anyone who doesn't feel comfortable being here, raise your hand and you're excused. And then the only hands that fly up are people over 40. And you're stuck with a jury that's entirely people under 40. Or all the women raise their hand and you only have a pool that you can pick from that's all men. Is this the opportunity to draw from a fair cross-section in the community? These are things that need to be developed. And if you see something like that happening, it's worth making the objection. Make the objection before they're sworn. So moving on to another topic, peremptory strikes. So some courts are starting to limit the number of peremptory strikes parties can exercise. And there's some concern that this one is going to hold on a little longer because, I mean, at least to me, when I first saw it, I thought, oh, bummer, I like peremptory strikes. But I guess that makes sense. It's just a strike of someone that you don't have a good reason to get rid of. Guess the court can take it away. And I think a lot of people may look at it that way. And so it's important to really dig into what limiting peremptory strikes is doing and how to form an argument about it. So as we said, why it's happening, there's a juror shortage. We don't have enough jurors to go around. So courts are reluctant to have attorneys excusing jurors for no reason that's related to cause or an actual excuse reason. Then there's efficiency. The process of picking a jury takes time, and a lot of courts are concerned about having that many people assembled. So the idea with peremptory strikes is usually the court gives them, the court can take them right away. Here are some states with examples who have limited the peremptory strikes during the pandemic. Arizona reduced from 4 to 2. Idaho also 4 to 2. And then there was no peremptory strike for an alternate or additional jurors. When you look at peremptory strike challenges, remember that context matters. We have a situation that's for public health and efficiency reasons has courts eliminating some of the in-person questioning in favor of questionnaires. You get less time with these jurors. We have judge-directed voir dire. Your judge is asking your questions. You're not asking them, and you maybe don't get all the follow-up that you would normally get. Questioning time is limited. When you are allowed to be in the room with these jurors, maybe you get 20 minutes instead of 2 hours. What can you find out in 20 minutes versus 2 hours? Then again, the leniency with absenteeism and excusals, and the overall effect of COVID-19 on jury pools. On their own, peremptory strikes may not seem like the most important issue until you look at everything else with it. What is this doing to your ability to select a fair jury on its own? So how do you make the objection? As I said before, my first blush instinct was like, oh darn, but I want them. Making a but I want them argument is something that my son would make, and he's 2. And judges don't really take kindly to toddler arguments. So you need to craft something a little better than but I want them. You make the thoughtful objections. Go back to the context. What circumstances in this trial would make your peremptory strikes more necessary? What would more peremptory strikes have done to this panel? Think about who you would have struck that ended up on your jury. And again, make those objections before the jury is sworn. Get them on the record. As with a lot of objections to COVID efficiency procedures, you may not win at the trial court, but when the appellate courts get a little time and distance from this, they may find that some practices that were commonplace during the pandemic and its aftermath didn't work well and were unfair, and you want to have that objection on the record, and a specific enough one to preserve the issue. So, as always, your best bet is going to be winning cause arguments. That's the case whenever you go to trial, because you always have a limited number of peremptory strikes. So now is the time to make sure you're putting the time into jury research. It's more important now than ever. What can you find out about your jury pool before you show up for selection? Make the most of the tools that the court is giving you. If you're doing questionnaires, think about your jury questionnaires. You don't want so many questions that the judge has an excuse to say, well, you only need 15 minutes of actually asking them questions. You were pretty thorough in that questionnaire. And you don't want them to be so minimal that you don't find out any information about these jurors. Have to be cautious about leading language in them. This is not something to delegate to a very, very junior associate without oversight. And it's not something to leave till the last minute and not give enough time. If you're given questionnaires, take the time to do them and do them well. It's more important now than ever with the other restrictions you may have to selecting a jury. Number 2, to the extent you have in-person questions, you must be efficient. If you're used to spending 3 hours selecting a jury and 25 minutes of that is light banter getting the jurors to like you, and now you're suddenly down to 45 minutes of jury selections, you have to get to the chase. Get to the point. Don't be unlikable. Still make the jury like you, but you need to find out who is going to be biased on your jury. You have to find them out. And then last, as always, know your for-cause strikes and use them well. Exclude the jurors that are not going to be fair to your client for cause. Have a reason to exclude them. Have a backup reason to exclude them. And force your opponents to use their peremptory strikes. A story I like to tell about a poor for-cause argument. We were in a trial, and there was a gentleman on the jury, in the pool, who was actively participating in jury selection, answering questions, answering them with nuance. But he was a character. He was kind of funny. We didn't necessarily have anything wrong with him. We thought he might be fine. But it was clear that our opposing counsel didn't like him and wanted him gone. Made the objection to the judge that he should be struck for cause because, Judge, he's a little weird. And the judge wasn't necessarily buying it, but she was somewhat swayed. Got up and argued, our lead trial counsel argued that that's not a reason, that people are a little weird and that's just part of the population. And ultimately, we forced our opponent to use a peremptory strike to get rid of this juror. So if you know your cause arguments, you can preserve your peremptories and force your opponent to use peremptories when a for-cause exclusion is not appropriate. With that, I am going to turn it over to Daniel to discuss some issues with in-person and hybrid trials.
Thank you, Amanda. All right. So as we've heard so far, there is a tremendous amount of pressure that courts are feeling to get through their backlogs. And this is demonstrated, in fact, by a lot of administrative orders that are coming out that have sort of a 1-2 punch. On the one hand, they're firming up their continuance policies and trying to pump the brakes on granting motions for continuance. And at the same time, they are incentivizing judges and parties to go forward virtually with virtual participation if possible. Now, this creates an atmosphere where there is some risk. And the risk is that a court may press forward with a trial even if the party representative, the attorney of choice, or even key witnesses can't physically be there in person. So it's important to keep your eyes open and see how these issues are developing legally, because there are relevant arguments for each category. But before we get there, let's talk a little bit about the context of a motion for continuance right now. It used to be, before the pandemic, that it was incredibly rare for a court to press through with a trial, even though the parties or the lead witnesses or key attorneys in the case couldn't physically be there. But COVID-19 has changed the attitude towards continuances. And the generalized fear that someone might not be able to make it to trial isn't going to be enough. Instead, you have to look at specific and non-speculative examples of how you're going to be prejudiced by non-attendance of key members of your litigation team. So if your trial is 3 months out, it's not enough to say, oh, well, maybe they're not going to be able to make it. You need to have concrete examples. And also be aware of what you could call traditional justifications for a continuance. If, for example, the discovery is incomplete, or if COVID-19 travel restrictions has precluded an expert from examining the scene of the accident or incident that's the subject of the lawsuit. Those may add good justifications to a motion for continuance. But also be aware that courts have safety protocols in place now. And these safety protocols are designed to the greatest extent possible to ensure that a trial can proceed safely. One thing to look at in this context is whether or not those protocols are sufficient in a complex case. It may be the case that the protocols don't take into account a situation where, for example, you have several parties, not just two parties, and many of the witnesses and party representatives are even traveling from around the country or even internationally. So the court's protocols might not have anticipated the logistical complications that are at issue there. And courts will be potentially receptive to this, especially if you can specifically point out the logistical hurdles. So keep those in mind, but also be aware here that the more a party tries to fight an in-person trial and ask for a continuance, the more risk there is that the court is going to respond by trying to compel virtual participation. So your party representative can't make it, let them appear virtually. So be aware of that, and be aware of whether the administrative orders in your jurisdiction permit a court to do that, one. And two, be aware of the specific judge who's trying your case and their preferences. So let's get into some specifics. A party has a right to be in trial in person. It's derived from the Fifth Amendment Due Process Clause. That being said, looking back over the past year, there are a lot of cases in the criminal context that are highly distinguishable. You see, in the criminal context, the right to be physically present in person at a trial is derived from the Sixth Amendment and the Confrontation Clause. So those cases are of limited value. Due process is certainly a flexible concept, and that's something that actually helps us here. If you think about it, the framers did not anticipate a global pandemic shutting down the courts, and on top of that, the possibility of a virtual participation in lieu of physical participation. So we're in a little bit of uncharted territory here. But that being said, we aren't completely without guidance from the past. We know from the past that the Fifth Amendment Due Process Clause protects a party's right to meaningfully participate at trial. And meaningfully participating at trial involves being able to physically communicate with your counsel and observe the proceedings in real time as the court is handing down rulings from the bench, as witnesses are testifying, and as the jury is taking in all of this evidence and reacting to it. So this is an important right of the party, and it's accentuated, in fact, in the corporate context oftentimes, where the party representative is an expert in the specific subject matter of the lawsuit and has a unique perspective to contribute to litigation strategy as the case is unfolding. This right is not absolute. There are exceptions. The exceptions generally focus on non-pandemic related contexts, though. For example, if you have a party who's being disruptive during the case, then of course there is an exception there that would permit a court to kick that disruptive litigant out of the courtroom. That's different. Also be aware that there is a circuit split about the application of this due process right. There are some cases that hold that it is not a due process violation if the party can't attend in person, but their attorney can. And it all stems back from this 100-year-old United States Supreme Court case that has a bit of ambiguity. That's the way it always happens. And so you have differing trains of thought on either end. Helminski is one case from the Sixth Circuit that says if the party's there in person, if the attorney's there in person, but the party can't be, you can have a due process violation. Koulos goes the other way and suggests that if the attorney is there, but the party can't be there, there is no violation. So how has this been interpreted by courts during the pandemic? The short answer is not many cases have actually looked at it. These are two that we've found that are worth considering. The first, Clarington v. State, came out of the 3rd DCA in Florida, and it balanced, in deciding that the right of a party to be physically present at trial was not violated. It balanced the rights of the community at large to have an efficient administration of justice. And it's important to note the context here. The court was very much aware of the fact that the pandemic was wreaking havoc on litigants' ability to safely conduct trials in person, and the temporary nature of this shutdown, the fact that there was no real clear end in sight at the moment that this case came out to when courts could hold trials in person again. So this case leaves open the possibility that the analysis will in fact be different as vaccines continue to be administered and courts continue to open up and work through their backlogs. The justifications based on the public's right to access the courts and to attain justice in their cases simply does not apply with equal force. Essentially, it would become a question of pure efficiency, that there are backlogs and that's sufficient to violate a party's right to be there physically in person. And that's just not the case. Another case to consider is Excol, which held that if a party participates virtually, then there is no due process violation. This case can be distinguished pretty easily because it wasn't a detailed analysis. And in fact, the court noted that the parties didn't actually go into any specific case law authority supporting their argument to be there in person. So the bottom line here is that we do have an argument that a party has the right to be physically present at trial, and that right is violated even if they are participating remotely because it impacts and inhibits their ability to communicate with their counsel and fully perceive the events as they're unfolding during trial. Another subject to be aware of is whether your attorney of choice can be present during the trial. The adversarial system in which we work is dependent upon the ability of well-informed counsel to ably defend their client's interest in front of the court. This is a qualified right, but it is one that has historically mattered. And this case is just one example where if the trial court were to deny a motion for continuance based on the fact that the lead attorney in a case became sick before trial, that could be grounds for a reversal on appeal. So it is that important. Witness testimony has been the subject of considerable debate during the pandemic, and in particular, whether or not virtual testimony is okay. Now, if you're in federal court and you're asking for a continuance based on the fact that a witness can't physically be present, the analysis is likely going to end up with looking at Rule 43. Rule 43 essentially says that there is a federal preference for in-person testimony, but there is an exception where there are compelling circumstances and good cause. So Rule 77 often comes into play here as well as further support for the proposition that courts prefer in-person testimony to remote testimony. Its exception is even broader, though. It's so long as it's convenient to hold trial in a regular courtroom. Courts during the pandemic have had the opportunity to look at these rules and interpret them. One case that's very important to keep in mind and that you should know is Gould. Gould is important because it's one of the first cases to actually go through a statutory analysis of Rule 43 and go through in detail the various aspects of the rule. It held that the pandemic does constitute a compelling circumstance, but importantly, it also noted that the context of the pandemic played a role in its decision. There was this ongoing severe public health concern. It was at the height of the pandemic. I think it was in July when this case came out. And it was unclear when in the future an in-person proceeding could occur. So that was a significant factor and one that was potentially, it's one that potentially will change going forward as courts continue to reopen. The court also minimized technological concerns about how witness remote testimony would be perceived. And that really deserves a closer look. So going back to before the pandemic, one of the things that you'll notice is there was a lot of hesitation towards remote testimony. And that hesitation focused generally on the fact that it's not as clear that a jury will be able to fully understand a witness's demeanor if they're watching the witness testify on a screen as opposed to being there in person. And by the way, remote conferencing technology isn't new. Skype, for example, and its video conferencing capabilities has been around since 2005. So this is not a new technology that's just come out during the pandemic. But then during the pandemic, you had this interesting progression of judicial thought. Early on, the cases sometimes would indicate the same level of distrust towards technology, and Hassoun is an example of that. That was exemplified in the earlier pre-pandemic case law. But then as the shutdowns continued and extended, and there was no end in sight, you saw more cases where courts minimized technological concerns, largely probably due to their experiences holding virtual hearings and things like that. So it has gotten to the point now where courts are even saying that based on their subjective feelings and their experience with remote technology, that they feel that the jury will be able to sufficiently evaluate the evidence presented through a remote means. Even now, of course, there is dissent between the various courts around the country, and some are still concerned about virtual testimony. This is one example where the court said the remote, sterile, and disjointed reality of virtual proceedings cannot at present replicate the totality of human experience. So there is reason to be concerned about the remote presentation of witness testimony. And this comes from empirical evidence, in fact. Science is telling courts that you do lose quite a deal of nonverbal communication. So nonverbal communication isn't just what probably first comes into your mind, whether or not you can tell if a witness is lying. That's one aspect of it. But it's also all of the various nuances that we communicate through our body language, whether or not a witness is communicating bravery or fear, whether or not gesturing is an effective method of communication over remote technology. If I were to try to communicate through gesturing now, my hands would have to be up here. And granted, some of this can be mediated, but by and large, a significant amount of nonverbal communication is lost. And also opportunities for nonverbal communication are also lost. The juror sitting in a jury box in a physical courtroom has a 360 view and can watch the interactions between the judge, the witness, the attorneys, the parties, and as various pieces of evidence come out, the juror can soak it all in. That's much different than a virtual proceeding where you have this tiny little box and you're trying to get the same experience from that tiny little box. And it's just not the same. Now, that said, the point here is not that science has a definitive answer. Not even the authors of this one article suggest that the answer here is conclusive. But this raises an important question, and one that's worth meditating on. Should we be focused on judicial intuition in terms of whether or not remote testimony is sufficient, or should we be listening to what the empirical and scientific evidence says on the question? The bottom line to sum up is that the context here is changing across the board. The justifications that at one point existed for courts are not necessarily true. During the height of the pandemic last year, before a vaccine was in sight, before courts were even considering reopening, there was a different type of pressure to keep the wheels of justice moving forward. But now, the vaccine is being rolled out. Courts are opening up. If they haven't opened up in a specific jurisdiction, they're going to, and the end is in sight. So what you have instead is a pure question of efficiency. You have a judicial backlog of a significant number of cases pitted against the rights of a party to be present with their litigation team in an in-person trial. And that is simply not the same. And so I'd like to end with this one quote that I like quite a lot. We're all too often reminded that justice delayed is justice denied, but it is equally true in some situations that justice rushed is justice crushed. And with that, I will turn it over to Wendy to talk about virtual trials.
Thank you, Daniel. Let me switch to this topic of virtual trials. And Daniel's talked about a number of the issues with witnesses, et cetera, that will affect and be the same when we talk about a virtual trial. So I won't duplicate that, but there's some specific concerns I want to talk about, especially related to the jury. But let me start by setting the stage a little bit. Courts are leaning into virtual technology. They like it. They're trying it, and they're finding it to be very helpful. At this point, courts in a number of states, Washington, federal courts in Florida, Minnesota, Massachusetts, California, Texas, Kansas, they're all having virtual trials, and they're liking it, and they're wanting to do it. Next. As you can see, the judges are favorably inclined towards it. One judge, this might be the only way the wheels of justice will still turn. A judge in federal court in Florida said, I would do it again in a heartbeat. Next slide. With that background, we're seeing more and more trials that are going to be virtual. Florida Supreme Court has now said they're going to hold virtual trials, other courts as well. Next slide. In particular, New Jersey has just okayed a remote trial procedure. They're ready to go forward with it. It's voluntary until April 5th, and after that, no consent will be required. So we might want to bury our heads in the sand and think that virtual trials were just a little temporary blip on the screen, but it seems that they may be coming on with full force at this point. So where's the beef about that? There's a number of issues that we can talk about, but intuitively, it seems like we don't want a virtual trial. We just know we don't like it. It's against everything a trial lawyer would say about having contact and being present in front of the jury. But the legal hooks are not so simple, and you heard some of those from Daniel already. But when we try to find the hook to make the argument, it may not be there in the case law. So we have to be thinking about the ways we can draw on the existing law to make the arguments that we want to make. Jury composition, Amanda's talked about that in the context of a live trial. Obviously, with a virtual trial, you have that issue as well in terms of jurors who may not be able to participate. But again, not something you want to raise too far in advance. Jury behavior is probably the thing that we've heard the most about, and we see all the articles about jurors who aren't paying attention. I think most of this comes from the fact that without the ceremony of the courtroom and without that feeling that I just walked into chambers or walked into a courtroom with a judge, the feeling is not the same. And it's been hard to recreate that in the courtroom setting. I'd love to say there's lots of law out there talking about how important it is to have jurors who pay attention. I'm sure we all know we've had cases where we've had to say, Judge, the juror's asleep, and the judge wakes them up and we move on. But there really is very little law where courts have talked about this issue of how important it is to have a juror who pays attention. Next slide. The concerns go beyond the behavior of the jurors. And I think about jury deliberations. Generally speaking, you think about a jury, especially in the cases that many of us are involved in, that are lengthy trials, and the jurors have time to build the rapport with one another. They get a feeling for who's who and who's going to be the leader of this. And they developed a relationship that just doesn't happen when it's a virtual trial. How can the court ensure that all the jurors are present when they're doing deliberations? We know when we lock them in a jury room and tell them to deliberate together that they're all there, but we don't know that if they're all at home and they're, taking care of themselves and hoping that when somebody says, I'm going to take a break for 10 minutes, that everybody understands they need to stop. How do they look at exhibits in a meaningful way? And when I say that, I mean, if you've got to have those exhibits in some form where they can pull them up and they have to get to them, it may just be more difficult for them. And they say, you know what, we don't need to be bothered with it. Also important is protecting the sanctity of that jury. Most jurisdictions, indeed, I'm sure all jurisdictions have rules that say we cannot get into an inquiry about what was going on during that deliberation process. Well, if we can't know what's going on, how do we know whether something happened as a result of a virtual jury and a virtual trial that otherwise might not have happened? How do we know that there weren't outside influences, that the juror didn't have his family having an influence on what was going on, that they weren't listening to what was happening? And the answer, of course, is that courts will say, we can have a 360 camera, we can do all kinds of things. But I would submit that it's still pretty hard to control what's happening when a juror may be sitting in a room and then walks out to take the lunch break and it's fresh on their mind. They're talking to their family members about what's going on. How do we protect against hackers? We've all heard stories about how those problems have arisen. How do we know somebody's not in that jury room, in that virtual jury room, when they're debating the issues? The logistics relating to the jury verdict form are another concern. In a recent trial, there was a problem when the foreperson couldn't transmit the verdict back to the court. That same jury didn't fill out the verdict form completely, and the judge said that was the first time she had had that happen. So you wonder, was that because they weren't sitting in a room working through it together and they really didn't get the understanding of it? That's a nightmare scenario to me as an appellate attorney, because I'm always worried about, is the verdict form filled out properly? Are there consistencies or irregularities in that verdict form? And those are bigger problems when we're dealing with a virtual trial and a virtual jury. Next slide. There's also difficulties with regard to supervising witnesses' conduct. Many of these are the same type of things that would happen during deposition, so I won't spend a lot of time on those issues. Technical issues, again, they can be small inconveniences. I might get logged off right now for a minute and I'll get back on. But the ones I worry about are objections that might be missed because somebody couldn't hear what was happening, or the inability to fully argue the legal position, or the juror who just wasn't paying attention during that critical testimony. And these aren't hypothetical issues. Again, I'm sure you've seen the articles coming out of especially the cases in California, the first asbestos trials, resulting in a number of problems that the lawyers ended up filing a notice of irregularity to identify technical mishaps that precluded them from hearing what was going on, the juror distractions. At one point, the judge had to remind the jurors to pay attention during the corporate rep deposition or testimony. None of this is what you want from a jury who's deciding your case. Next slide. Another significant issue relates to confidentiality. At least one judge recently in an article noted that she's drawing a much bigger crowd for her virtual trials. People are sitting at home and they're going, oh, this looks interesting. I think I'll pay attention to something. when most of us are used to having a trial with no one in the courtroom or very few people. This is a real concern if you have confidential documents. In the old days, you could ask to seal the documents, you asked to seal the transcripts, you could ask to seal the courtroom. Courts weren't likely to do that, but at least you could look around and say, Judge, there's nobody in the courtroom. I haven't waived any confidentiality. But what do you do when you have a virtual trial? Next slide. Fortunately, many courts have put some procedures in place already and have some protocols to address confidentiality issues. So you want to check the local rules because they will provide some guidance. I was also happy to see that many courts will limit the public's access. When there's going to be issues of confidentiality, they'll just say the public can participate, but they can't participate by video. They can only listen to the audio portion, and then the court has the control to shut it off during testimony that's confidential. So that's something that is very important, but courts have addressed. So how have courts handled these objections? I'd like to tell you that these things that I've just described have been great and courts are buying them, but obviously they haven't because trials have been going forward. So I thought it was important to provide a couple of citations to cases where courts have walked through the different objections that we've talked about today. And unfortunately, they have rejected these. But again, I think you need to see them in order to make your own arguments. You know that the plaintiffs are going to find these cases and talk about them. The Kansas case in particular pretty much walked through everything we've talked about today and said, nah, I think I can solve all of those problems. I'll give really good instructions. I'll make sure I know what's going on and I can handle it. Remains to be seen if that's true or not. The same thing in Washington, which has now done several trials. So it's a little bit difficult in that jurisdiction. Nonetheless, I think it's important that you know these cases and then think about in your particular case, what arguments do you have that make your case different than another case, these reported cases, and how can you argue it in your case? Next slide. The other issue is, when do you raise these challenges? I know as an appellate attorney, I want to object. I want to make my objections. I want to think about taking it up. But I think we have to think about when is the right time to make the objection. Many of these challenges, when appellate courts have looked at it, they've been in the abstract. It's been before the trial. And the complaints are out there, but they haven't happened yet. And that essentially the courts are saying, we can control that. And so while it's important, I believe, to make the objections in advance and file those motions, when the court denies, or if the court denies it, the question is, do you try to file the writ at that point and get relief? And I would suggest that that's something to think about very carefully, because if you do file it, chances are courts are not going to be receptive to it because it's just the parade of horribles that hasn't happened yet. And once that appellate decision comes down, then the court may be emboldened to proceed forward. So it may be that you just have to wait and make what I would call the as-applied challenge. When the problems are arising, start making those objections and preserve. Now that obviously doesn't apply in every case, but it's just something to think about whether or not doing it too soon will present a problem. Next slide. On the bright side of it, some of the virtual trials have actually had very good results. Two cases recently, a California asbestos case, the one that had all of the objections and the notices of irregularity, it turned out that there was a defense verdict. There was a recent defense verdict in Washington as well. But the lawyers who have handled those cases have pointed to some positives. They've reported that jurors seem to be a little more candid. There seems to be maybe a little less emotion when everyone's not in the courtroom. But everyone that I've spoken to and I've listened to in presentations has said, don't take that as a sign that you should agree to a virtual trial. Happy to have the results we got, but it may not be the best idea to allow that to go forward in the future. Next slide. So again, trying to turn to some positives. What can we get out of all of this that might help us going forward? Again, as an appellate attorney, one of the things that's really important to me is to be able to file all the motions in limine and get rulings on them in advance. It happens in federal court. It doesn't happen very often in state court. Many times the jury's out in the hallway and the judge is trying to rule on motions in limine, which is not the best way to get the rulings that we want. I posted here an order from Miami-Dade County that I particularly like because it requires a number of steps to be taken before the jury, before there's going to be a jury trial. And it requires that the court hear all of the motions in limine and get those resolved and pretty much get everything in place so when the trial starts, things can proceed forward. Of course, the caveat is that doesn't mean that we can rest during the trial and not raise objections. We still need to do that. But getting things resolved in advance, I think, is something that's very positive and that we would like to see going forward for all cases, and trying to get judges to understand that these kinds of orders would be really helpful for us. Next slide. So what do you do when a court's ordered a virtual trial? Again, I go back to the same point that Amanda and Daniel made. Have to have a plan. On the technical side of it, the things like making sure the court's going to have tech support from court staff. Many of these trials, there's somebody dedicated just to the issue of technical support, making sure things are all set up, making sure jurors have proper equipment and the proper internet connection, a jury questionnaire to make sure that they have the support that they need and they're able to stay connected, asking more detailed questioning during voir dire. There's an order in New Jersey when the court allowed the virtual trials, very detailed about what's required. And one of the things the court said was, we're going to allow a very open-ended questionnaire to see what jurors feel about virtual trials and their ability to participate in those trials. So that's a really good suggestion. Next slide. On the more substantive side, making sure there's instructions, strong instructions about proper conduct. I don't know that they'll really help, but we want to make sure we ask for the strongest instruction that we can have. Make sure there's a procedure to ensure objections can be heard and considered. Raise your hand, whatever it is. We can't let an objection go by and then later on say, well, I couldn't get that objection in if you haven't established a plan to do so. The plan for exhibits in a virtual setting, I think everybody's getting used to that for just dealing with it during depositions. Having a trial schedule that allows the jurors to take the kinds of breaks they need so we avoid juror fatigue. Making sure the lawyers are going to be able to talk amongst themselves and with their client, consistent with what Daniel was talking about. Also making sure that the record is very clear about what happened. We always talk about, the record is only what's on the piece of paper. So if a juror was blocked out for a few minutes of testimony, make sure to make it very clear on the record exactly what happened and be the eyes and ears for the appellate court to see where the problems were. And again, I can't say it enough, preserve, preserve, preserve. Next slide. So it certainly appears that the virtual trials are here to stay for a while, and many of the other things that we've talked about today, the more limited jurors, all of those issues may very well be here to stay. And so where does that leave us? And I go back to where we started on this. Don't limit your thinking and your decision-making to the impact on trials in the next few months or years. Remember that whatever we agree to today in the name of expediency may in fact become the norm after the pandemic is behind us and the backlog's addressed, and we may have to live with those issues. We don't want to look back in a few years and wonder how it all ended up with us having less jurors or whatever else, whatever other problems have arisen. And don't be dissuaded by the fact that there is no case law or the fact that I just showed you some of the really negative case law on these issues, because we've got to make the law. And it's really important that we think creatively about our issues. We draw on what we can draw on, which is what we tried to do today to provide you some case law that's prior to the pandemic. Draw on that to make the best possible arguments so that we're not facing an appellate or facing a verdict and then saying, I wish I would have thought about that. I wish I would have made the objection. So with that, I'll turn it back over to Glenn.
Thanks, everyone. Again, if you have a question for our presenters, please type it into the Q&A form in the chat box and send it in, and I'll ask it. We are up on an hour just about, but I'll have a couple of questions for you guys. What potential lasting benefits do you see coming out of this, especially ones that might be advantageous to civil defendants.
Well, I'll make a few comments. I talked about the simple things as an appellate attorney, what I care about, things like getting motions done. But I think overall, and it's not something we talked that much about today, I think it's going to change the way that trials are presented generally. We hear a lot of discussion about maybe we didn't need a full day with that expert. Maybe there was a tighter way to present our case. I think it's also interesting that right now, if a juror couldn't be present, it was a video deposition. The notion that if you can't get your witness there, while we'd rather have them live, we might prefer to have a live video than a deposition read. So we may be able to get some changes there that are beneficial. But I think it's just going to change the way we look at how we try cases and the level of patience that a jury has to sit in that courtroom.
Daniel, any thoughts?
Yeah, I have one thing that I think will probably be here to stay probably forever. Simple, non-evidentiary motion calendar hearings. And the very short, 5-minute hearings, those will probably remain virtual hearings going forward because it's far more efficient if it's, a quick case management calendar call or something to do everything remotely than all of the attorneys having to, spend 30 minutes driving to the courthouse, 30 minutes driving back. There's a lot of benefit in that context, especially where there are no evidentiary issues at play.
Beyond the specific context of trial proceedings, pre-trial proceedings have also been temporarily transformed into more virtual settings. How have those changes affected an attorney's ability to represent their client?
I think it depends on the case. As Daniel said, being able to get those motion calendars and getting those things resolved is great. I can tell you from my experience, I'm in Florida. I have a case in Wisconsin. We've probably had 4 or 5 hearings since the pandemic. And yes, we're getting through it. But personally, I would rather be next to my co-counsel, talking to them and having that interaction. And I really miss having that. I like that we could have the flexibility going forward. But as far as I'm concerned, I'm ready to get on the airplane and sit next to my trial lawyer and talk things through as we're going through it. And I miss that terribly.
Daniel, any thoughts on that?
No, ditto.
Okay. Have either of you heard of any or know of any sort of efforts by the organized plaintiffs bar to reach out to courts to try to get them to keep certain aspects of what might be favorable towards them after the pandemic is over, or as there's more courts that are opening up to in-person activities?
I don't know of it specifically, but I'd be shocked if it's not happening. I'm sure they're having the same kind of webinars we're having and going, we love less jurors. How are we going to keep that? That to me is one of the most obvious ones. It's a real problem. So I expect it's going on. I haven't seen it specifically, but then again, they don't invite me to their presentations.
So Amanda, what's been your favorite change of everything that's been changed as this has gone forward? Oh, don't have her audio, unfortunately.
Amanda's doing the demonstration of the problems that happen when you have to do things virtually.
Yeah, unfortunately, you're right. Sorry about that, Amanda. As an appellate lawyer, Wendy, how have you sort of adapted to oral arguments being conducted virtually?
I've done several. It is an interesting thing to sit in my home office to do an oral argument. There's parts of it I really like. I can have lots of notes everywhere. There's parts of it I don't like, including I like to have my co-counsel, especially I like my trial lawyer next to me when I argue. I've heard some people talk about really enjoying the fact that they can have notes everywhere. They can have a room full of people providing guidance. Personally, I wouldn't do that because I'd be distracted. I want to stay focused on my argument. But I've heard a lot of people say that they like it. And I have seen that some courts are saying they're very comfortable staying with this virtual format. I think it also depends how courts do it. In Florida, the courts that I've been in front of, they've had a normal panel. So they're jumping in on each other. In other courts, they're now doing it one judge at a time. I don't think that's the best way. Personally, I think the interaction from the judges, one reacting to the other and answering, think something is lost when they're doing it seriatim. But every court's different. And Florida's certainly allowing the same old thing. Maybe they hesitate a second before they interrupt each other.
Daniel, you've recently had a judicial clerkship. How do you think judicial clerks are managing all of this, and how might that make a difference to any given judge?
Well, I'm sure it's an exciting time with all these novel proceedings and trying to experiment with a new way to do things. From a purely ceremonial perspective, one of the coolest parts about being a clerk is that when a trial is going on, you get to physically go to the courtroom and watch, these huge attorneys and litigate these big high-profile cases, and you're physically there in the courtroom, or in the case of an appellate court, you're still there in the courtroom watching it all unfold. And that may be lost a little bit, so that's a shame. But at the same time, this is making history. So I'm sure they're all very excited about it.
Well, seeing that we have no further questions from our audience, I'm gonna bring this to a close. Thank you very much, everyone, for joining us today. Thank you, Wendy and Amanda and Daniel. And as I said, this will be available as an on-demand file later this afternoon on WLS website. Everybody have a great rest of the day.
Thank you.
Thanks.